Okay, so moving on, let's take a look at a corporation. So, a corporation is a separate legal entity created under a state statute by filing its organizational document or articles of incorporation with the proper state authority. The corporation is treated as a legal person with rights and obligations separate from its owners and managers. So, contrast a corporation with a limited liability company and a partnership is a corporation is wholly on its own. It's a separate type of legal structure or legal business structure. It's also created under a state statute, much like a limited liability company is, but its internal structure is different because instead of having members much in the way an LLC does, instead it has a board of directors and shareholders. So, corporations that we must think of are owned by shareholders or owners who elect a board of directors and approve fundamental changes in the corporate structure vis-a-vis these board of directors. So there's four types of corporations. There's a close or closely held corporation, which is owned by relatively few amounts of shareholders, doesn't sell its stock to the public, and is commonly owned by its officers and directors and has shareholder managers. So an example of a closely held corporation would be a company like White Castle, where White Castle, instead of doing franchise agreements, instead they own their own shares. They don't sell their shares on a public stock exchange, and a majority of its shares are owned by its officers and directors. In a lot of the same way, Walmart used to be a closely held corporation, but has since gone public. So that is something to keep in mind when you think about a closely held corporation, is whether or not its stocks are available to the public to buy. The next type of corporation is a foreign corporation. So this is just a term given to a corporation that is registered in another state but is trying to do business in a current state. So it's simply a business in another state other than the one in which it's incorporated. So usually a corporation that's incorporated in state A but wants to do business in state B would get a certificate of authority to do business in state B. Pretty self-explanatory. Next, we have an S corporation. So an S corporation is simply a special type of corporation that has elected under federal law to be taxed like a partnership, and therefore they do not pay the corporate income tax rate. Contrast this with a C corporation, which is taxed at the corporate income tax rate. And we'll go into S corporations a little later on. Next, we have professional corporations. So these are corporations that give accountants, lawyers, and other professionals the benefits of incorporating, but are limited to stock ownership to the specific professionals licensed within that state. So a lawyer in New York could set up a professional corporation of all lawyers, but the ownership in that corporation in the form of stocks could only be held by lawyers in that example. So how is a corporation formed? Well, incorporation is within the state government, and typically a document called the Articles of Incorporation, which is the corporate charter, is filed with the Secretary of State. This is exactly the same as a limited liability company. So the incorporators, there usually is 3 to begin with, but only one needs to sign the articles. And the articles must include the corporation's name, the number of authorized shares, the name and street address of the corporation's registered agent, and the name and street address of each incorporator. So after these articles of incorporation are filed, the incorporators elect the first members of the board of directors, and we call them the directors. And a lot of the time, the same people that are the incorporators will elect themselves as the initial board of directors. Any incorporators that don't then resign. So once the initial board of directors has been named, then the board of directors holds an organizational meeting. And they, in this meeting, take all the steps necessary to complete the organizational structure. And usually in this first meeting, the board will adopt the bylaws if they weren't adopted already. And the bylaws essentially govern all of the internal structure and operational processes of the organization. So the board of directors usually has a minimum requirement for the number of directors sitting on that board of directors, and each state has a specific requirement. Many states require a minimum of 3. New York requires a minimum of 3. So what's the authority of the board? Well, the directors, they formulate the overall policy for the corporation, but they're not treated as trustees or agents of the corporation. Remember the difference between an agent and a principal. A director cannot act individually to bind the corporation. He must get board approval and by a majority vote. A director cannot just go out and make decisions on behalf of the corporation. Everything is subject to board approval. This is different from a partnership in which each general partner of a general partnership is both an agent and a principal of the partnership, in which they are authorized by the partnership to go and act on the partnership's behalf. In the example of a corporation, a director cannot do so, cannot act individually to bind the corporation to third parties. Instead, there must be board approval. So, directors, they also owe a fiduciary duty to the corporation to act in its best interests, be loyal to the corporation, use due diligence in discharging responsibilities, be informed about the information relevant to the corporation, and disclose conflicts of interest. So let's look at this example. Skip, a director of the Fishing Corps, learns in his corporate capacity that a state-of-the-art deep-sea hydroplane fishing vessel is available for a bargain price. The purchase of this unique hydroplane may be a business opportunity from which the corporation could benefit. If Skip purchases the hydroplane for himself without giving the corporation the right of first refusal, he is usurping a corporate opportunity. So here you have Skip, who's a director of a corporation, and he learns while operating as a director that there's a new plane that's available and there's a really good price on it. So because the corporation is involved in buying these types of products, and there is a bargain price, which is an opportunity for the corporation, if Skip, because he was operating as in his corporate capacity to learn about this bargain price for this fishing plane, if he decides to buy it for himself without informing the corporation and giving the corporation the opportunity to buy it before him, which is the right of first refusal, he would in this scenario be breaching a fiduciary duty, and in this case he would be not essentially acting in the corporation's best interest or being loyal to the corporation. And usurping a corporate opportunity would then violate the first and the second fiduciary duties that directors owe to corporations. So we just learned about directors, who are the ones that make all the decisions for the board. But what are officers? So officers are elected or appointed by the board. So generally, the officers are the day-to-day managers. They manage the operations of the corporation, and the board can't remove an officer without cause if they're elected or employed by the shareholders at large. So usually, and these will be familiar to you, The usual officers are a president, vice president, secretary, and treasurer. And keep in mind, a director may also be an officer, and an officer may be a director, vice versa. They're not mutually exclusive. Think of a corporation as a mini federal government in which you have Congress, who writes the laws and is elected, right? That's the board of directors. And then think of the shareholders as the voters, and then think of the officers as the executive branch, which is the president, the vice president, and the various secretaries of the agencies. These are an easy way to understand what an officer is in the context of a corporation. So, unlike directors, officers are agents of the corporation and can manage the corporation. They have the express authority conferred by the bylaws of the board, right? And then they have implied authority to do the things that are reasonably necessary to accomplish their express duties. They also owe the same fiduciary duties to the corporation that directors owe to the corporation. So just keep in mind, officers are the agents, whereas directors are not. And that's the distinction. So what about shareholder rights? So a shareholder is an owner who might own shares in the corporation, but they have no direct rights to manage the corporation. The only rights that they really have is participation in an annual meeting, and they can elect the board of directors by a plurality vote. A plurality is simply the person who gets the most votes. They don't need more than 50% of the votes, they just need the most compared to anybody else. So the shareholders also are the ones that approve fundamental corporate changes. So these would be mergers, share exchanges, a sale of substantially all the assets of the corporation, the dissolution of the corporation, or amendments to the articles of incorporation that may materially or adversely affect the shareholders' rights. Lastly, we come to a concept called piercing the corporate veil. So this happens, so generally think about this, is a corporation is shielded from liability because it's a separate legal entity from its directors and officers. However, sometimes when the directors and the officers act in a wrongful manner, or they do something that goes against the fundamental basis of the corporation, or they're breaching one of their fiduciary duties, then a judicial court might come in and hold those directors and officers liable as individuals. So in this case, they would be piercing the corporate veil, which is destroying the corporate protection that is normally afforded to these individuals. So they would disregard the corporate entity, and in order to do so, the court has to find that the shareholders have not conducted the business on a corporate basis. So perhaps the assets of the corporation and the people that own the business are commingled. Perhaps the corporation was formed on a sham purpose to begin with, and perhaps there's formalities that are ignored, or the corporation is inadequately capitalized to carry on what it purports to do. So let's look at this example. Jennifer organizes a corporation with capital of only $500, intending to buy goods worth $1 million on credit. Jennifer expects to pay for the goods from profits generated from sales. If the business is not successful, she expects not to be personally liable because the purchase was made in the corporation's name. Because the corporation is undercapitalized, creditors may be successful in piercing the corporate veil, and Jennifer could be held personally liable for the debt. In this situation, if Jennifer starts a corporation with only $500 but wants to borrow $1 million and then expects to pay back that loan with the profits from borrowing the $1 million, if it doesn't happen, then she would be liable because she's essentially inadequately capitalizing the business itself. This is when the creditors will sue Jennifer directly and pierce the corporate veil. And hopefully that's a good example for you to understand.